Hey guys, this is Navdeep Singh Jittal. Thank you for clicking the channel. Today we are talking about a new case here. This is an application for visitor visa for Canada and it got refused, and we will see what happened, what went wrong. So the applicant name is Mr. Arun Kumar Singh. He is an Indian citizen who applied for a temporary resident visa to visit British Columbia on a letter dated September 21st in 2018. A visa officer in Ottawa refused the application. Apparently, this person applied online. So the applicant has now applied under subsection 72.1 of Immigration and Refugee Protection Act SC 2001 for judicial review, and he asks the court, among other things, to set aside the decision and return the matter for redetermination by another officer. Let's look at the background. The applicant's stated purpose for visiting British Columbia was to explore business opportunities and perhaps settling in the province. So his application for a temporary resident visa included an affidavit of his sister, who is a Canadian citizen residing in British Columbia, who stated that her brother wanted to make an exploratory business visit to Canada. He would stay with her, that she would be responsible for providing him food, shelter, other necessities he may require during his stay. Prior to his application for temporary resident visa, the applicant had visited Thailand as a tourist on 3 occasions. In his application, he disclosed that he had been refused a temporary resident visa to Canada in July 2013. He indicated that he had approximately 181,000 Canadian dollars to fund his Canadian stay, and his family members would not be accompanying him. He also indicated that he had significant assets in business ventures in India, which made him economically well established there, and thus he had strong ties to India and every intention of returning at the end of his proposed trip. The officer's decision was based on different factors, and we will see how visa officer evaluated the factors. So the visa officer was not satisfied that the applicant would leave Canada at the end of his proposed stay as a temporary resident, as stipulated in the immigration regulations, based on travel history, purpose of visit, and absence of legitimate business purpose in Canada. So the officer's GCMS notes are here. The officer says, I've reviewed all the documentation provided for this application. Summary of key findings below: integrated search record noted, no adverse info, PA like principal applicant demonstrated no international travel. See travel history on the file. Client wishes to visit Canada from September 15 to January 31st, 2019, probably 3 or 4 months. So invitation letter from the client's sister states that the applicant or the client will be coming for an exploratory business visit. No business invitation provided. Client works as a self-employed real estate agent. PA doesn't appear to have a legitimate business purpose. Given the foregoing, I'm not satisfied on the balance that the proposed travel is credible. I'm therefore not satisfied that the PA is a bona fide visitor will depart Canada, and application refused. As this publication indicates that the client visited Thailand thrice in the past, because the Thailand and Canada are completely different countries, the visa officer couldn't establish whether the applicant would be compliant to the temporary regulations in Canada. So travel history is the one reason. Purpose of visit: the applicant stated that he would be doing an exploratory business visit, but obviously if he was that much interested, he would have done the business visa application, wherein the applicants are required to submit all the comprehensive documentation, including their incomes, including their funds for investment, and there's a long list of documents submitted with that application, and that takes like 3 to 4 months. And after 3 to 4 months, if your application is approved, they'll invite you to make the exploratory visits. But there was nothing like that on this file. There was no legitimate invitation, so hence the third ground is there, which visa officer noted, that absence of legitimate business purpose. He could have established the purpose. Let's say something is going to happen, family, and he's supposed to attend that, and that could have been a much stronger purpose rather than this one. Thirdly, which I believe is, as per the current trend, he shouldn't have applied alone. He should have applied with her wife, and the purpose could have been different. As I mentioned, it could have been an occasion or something. the exploratory visit, which is for 3 to 4 months. That is looking suspicious to me already. So visa officer must have noted so many other things, I believe. Here is the review. The applicant says the officer committed an reviewable error by ignoring or incorrectly weighing the evidence. The applicant's view that it was unreasonable to require a business invitation considering his purpose in coming to Canada to explore investment opportunities in person. So if he's saying that he's exploring the investment opportunities, people can do online research, and I think if you're looking forward to do something like set up a business or something, you need data, you need analysis and everything. So in the applicant's view, that it was unreasonable to require a business invitation considering his purpose coming to Canada was to explore investment opportunities in person. According to the applicant, the officer failed to consider his connections to India, specifically his family and ties in public. So I see, we don't know his age. First of all, it seems to me that this person might be around 30-35. So people around this age mostly find it difficult to score a 777 and do the typical traditional way of express entry and get the PR. So people who are not able to do that, they try this way. Because he was applying alone, that was a big negative for me. And secondly, obviously the purpose of visit was not legitimate. So as I mentioned, he could have done something different. Probably he could have applied for some occasion, and he must have applied with his wife, to be honest. The other factors are gonna remain in place, and you'll have to satisfy the visa officers that you have strong ties in India. But these are one or two things which are basic, which can be improved. The matter was reviewed by the federal judge closely, and at the end the matter was dismissed. It means the officer's decision was reasonable. Mr. Arun Kumar Singh will have to reapply again maybe sometime in future. So the learnings from this case are, if you are between 30-35, you're earning more than 7 to 8 lakhs per year, and you do not have substantial travel history, but you have connections in Canada, you must apply with your wife for some occasion. It is most likely you might get the visa, you might not. It also depends on the presentation, how you present your case, and obviously the visa officer is gonna assess all those factors in their own way. But still, there is some documentation which can be done precisely and professionally. So if you're looking forward to the same, you can even get in touch with us. We can better help you to do the same. If your visa application has already been refused and you're not able to understand what went wrong and you did everything correct, but still it's a refusal, so you can better get in touch with us. We can possibly look at some of the possibilities, which if will be feasible will proceed, otherwise will suggest you accordingly. I hope it will help you, and I'll see you in the next video. Thank you.